Hey, Chris, how you doing?
Michael, good morning. I'm doing great. How are you?
Not too bad. Thanks for asking. So today we're gonna finish up our lengthy summer series about DWIs and what it could mean. Last week we touched upon refusal hearings and hardship licenses, and now we're gonna go back to what happens at the end and then what could go moving forward. So let's assume for just kind of going along through the process that you've gone through the refusal hearing, you've got or didn't get a hardship license, doesn't matter. Now we're actually at a trial or a hearing, or what is it? What happens when you actually have a DWI and you're past the point and the judge is ready to make a decision? Can you walk us through what happens there?
Well, before you get to a trial, there would have been some type of plea negotiations going on between the defense attorney, such as us, and whoever the prosecutor is in whatever county in New York. There's 62 counties, so there's 62 different DA's offices. They all have different policies with respect to plea bargaining DWIs. Some counties have very, very strict policies, such as Nassau, such as Westchester. And if you don't fit into the criteria for being offered a plea under their policy, then you have to sit with your attorney and make a decision about whether you're going to take the shot and go to trial or not.
Okay, so let's pretend, I guess, just for the purposes of this conversation, that we've decided to take that shot. Can you walk us through what a trial could be, like what it looks like?
Sure, a trial is after the plea negotiations have broken down, and typically the difficulty with a trial is that you have a client who, if the client is convicted after a trial, whether it's in town court or a village court or a civic city court if it's a misdemeanor, or in county court if it's a felony, the difficulty of the situation is that you are potentially facing jail time.
Oh,
And it could be something more than the local jail that exists in most counties. It could be a state prison, and people find it hard to believe, but there are people who are in state prison for DWI convictions, where there's not even any aggravating circumstances, such as an accident where somebody was injured or a fatality. So if you're going to be going to trial, you've got to spend a significant amount of time with your attorney prepping the case for trial and making that all important decision about whether you, as the defendant, are going to testify or not. And if you, as the defendant, are going to testify, there's even more preparation, because people always think, well, I'll get on the witness stand and I'll tell my version of the story. And it's not that simple. There's typically pretrial hearings before any trial, whether it's in one of the lower courts or whether it's in a county court. And those pretrial hearings center around whether there's statements that had been allegedly made by whoever the defendant is, the client, on the day or night in question. And if those statements are incriminating in any way, typically in a DWI case, the incriminating statement is in response to a question from law enforcement, where are you coming from? That's a very typical first or second question. Where are you coming from? Do you know why I pulled you over? Things like that. If you say at 2:30 in the morning that you were coming from a bar, or that you were coming from somebody's party, that makes the bells and whistles and alarms go off in whoever the police officer or trooper's brain. And then they ask you that even more incriminating question: have you consumed any alcoholic beverages? And this line of questioning also applies in situations where somebody has been consuming either street drugs or prescription medication, because you can be in the same situation for driving while impaired by drugs.
Right. So if you're on the stand, what you're saying, just so we kind of clarify that, they can pretty much ask you about anything that you talked to them during the whole process, and in the event that you were possibly under the influence, you may not have remembered what you said, and that's what's the incriminating part. Is that what you're saying?
Well, it's the incriminating part is that typically most people I find, they'll give a straightforward answer to a question from a trooper. They won't say, well, before I answer your questions, I want to talk to my attorney, because it's typically somewhere out on a road somewhere, and the person doesn't have an attorney who's convenient at 2:30 in the morning to speak to and inquire. I'm being asked these questions by the trooper or by the police officer. And typically, when it's at that stage, in that type of setting, roadside, you're still in your vehicle or you're standing next to your vehicle and you're being questioned, the trooper or the police officer is not going to wait for you to call your lawyer. They'll typically tell you that once they finish what they're doing, then you can speak to your lawyer. So you have to decide what you're going to tell them. If you've already told them, yes, I've been consuming alcoholic beverages, or I was coming from a bar and it's that hour of the night, they're then going to walk you through the field sobriety test that we spoke about several weeks ago.
Right.
All those issues become issues that have to be raised in pretrial hearings, because typically, if you're going to trial, it's not the first offender case that goes to trial. It's a case where somebody has at least a prior conviction for an alcohol-related offense or a drug-related offense. And the pretrial hearing is designed to determine whether those facts, the fact of a prior conviction, Michael, will be admissible before a jury in a trial, because you don't want a jury to hear that your attorney's telling them that on the night in question that you were not intoxicated, but the prosecutor is going to tell them that you already have a prior conviction or more, 2 or 3 prior convictions potentially, for driving while intoxicated or driving while impaired by drugs, because it's so prejudicial for a jury to hear that they're not going to reasonably be expected to sort out that on the night in question you weren't, but yet you have these prior convictions. So that becomes fodder for pretrial hearings, along with pretrial hearings to do things like suppress the statements that you made on the roadside in the dark of the night before you got a chance to speak to a lawyer. And these are questions that the trooper will either write down immediately or when he or she is back in his cruiser. And so those become the pretrial hearing issues before you get to picking a jury and having an actual trial. But if you have a trial, one of the big issues also becomes, and it's depending on what the rulings have been on the pretrial hearings, Michael, whether you as the defendant are even going to testify. Because
Right.
if you testify as a defendant in a criminal case, you really do open yourself up to being questioned about almost anything, not just relating to the night in question, but about any prior history that you may have, which,
Wow.
as I said, can be extremely prejudicial.
Right. So let's talk about what happens after the trial. So let's say you're convicted, you're found guilty. What does that mean?
Well, it can mean that you are immediately incarcerated because
Oh wow.
typically plea negotiations would have broken down, or there may not even have been any plea negotiations because you may not have fit into whatever the criteria are in some of those counties, as I indicated earlier, that have very strict DWI policies. So if you are convicted, very often a prosecutor will say to a judge, the defendant has now been found guilty by a jury. We would ask that his or her bail be revoked and that he or she be incarcerated. And it's very few counties. In the old days, you could walk out of court after a conviction in a local court on a DWI many times, and you would be facing, at worst, probation. It's not that way anymore because DWI cases are more strictly prosecuted than many other types of crimes by prosecutors' offices, because when prosecutors run for election and campaign for election, most people outside of the city of New York, by that I mean Manhattan, the Bronx, Kings County, Queens County, most prosecutors campaign on being tough on DWI, tough on DWI, tough on DWI. And so if they're elected, they believe that the taxpayers who voted in that election where they were elected district attorney, that those prosecutors expect them to be tough. And that's why they have such tough policies in places like Nassau and Westchester, and policies that may be a little different and far less case-oriented than in other counties in New York State.
Okay. So do you think if you're found guilty at trial, is it possible you can just get probation?
It's possible, but it's becoming increasingly less frequent that happens. Typically, you go to trial and you throw the dice. You're going to trial because they've offered you a plea that is a jail plea in plea negotiations. And so you know going into trial that you are facing a jail cell if you're convicted.
What about rehab?
Rehab is, if you're waiting for after trial to go to rehab, those of us who live in this world have heard many times that the rehab is jail. And so rehab is something that really, if rehab's appropriate, rehabilitation, some type of drug or alcohol rehabilitation, it's typically a conversation between a lawyer and a client that takes place in the early stages of a case, where there's a determination that's made between the lawyer and the client that the client has an issue or a problem with alcohol and or drugs, and that the client should, for his or her own good, take care of that right away. And by the way, it won't hurt your case if we can show that you acknowledge that you had a problem with drugs or alcohol, that this isn't your first offense, and that you have gone to some type of an intensive outpatient or an inpatient type of program that's more than once or twice, and that you have addressed the issue.
All right. So I guess the last question I got for you is, win, lose, or draw at trial or a plea, what happens if you get pulled over again for a DWI?
Well, if you get pulled over again for a DWI, hopefully you were partaking in the first and second of this series sessions that we had, where I discussed that you don't want to have a police officer smelling alcohol on your breath. You don't want to have a police officer smelling weed just got smoked in your car. So you can't treat your car like your living room. And if you have been consuming alcoholic beverages or even smoking weed, because it does stink of weed coming from you if you've been smoking it, that you have something to mask the odor.
Right. So what about in terms of your future legal? Will it always be there?
Will what always be there?
Yeah, the fact that you went through this process beforehand.
The record will show from long, long ago. And I have clients come back to me from when I first started doing this 35 years ago, Michael, and they see on a rap sheet that there was that conviction from 1989, let's say. That conviction will stay on your rap sheet. And in some of those counties that I've mentioned that have very strict, tough policies, the fact of a prior conviction, even if it was remote in time, even if it was 25 years ago, will very often prevent any type of plea negotiation between you and the prosecutor's office. So those records never disappear.
Well, thanks, Chris. You talked us through all about DWIs and this summer, and it's been really great to know kind of what it is. And do you have any advice if anybody finds themselves in this situation, what they should do?
Well, as soon as you can, you contact a lawyer who does this type of work and speak with the lawyer at length about what your rights are and what you can expect to have happen if you've been arrested for DWI. And as I've said before, it doesn't hurt to have an attorney on speed dial on your phone. And I tell clients that all the time. It doesn't cost you anything to call me at 2:00 in the morning, and I answer my phone at 2:00 in the morning. I had somebody call me the other night at 4:20 in the morning about a DWI, and he was in the process of being pulled over. And you could hear in the background that there was the police cruiser that was directly behind his car. So you knew that he had at some point listened and heard, and either from myself or somebody else had decided that having somebody on speed dial, which didn't cost him anything, it just gave him the ability to speak to me 2 nights ago. And by the time the police officer got out of his cruiser and got to my guy's car, my guy had the answers to some questions that were the first questions that trooper was asking him.
Great. So we'll make sure the number is available for people to call. And thanks a lot, Chris. It's been really informative.
Thank you, Michael.